The African Union is in the process of creating an African court, whose mandate would be to deal with international crimes, including crimes against humanity, war crimes, and so forth, to be based in Arusha.
This move to have a continental court, which is expected to be based in Arusha, Tanzania, has received accolades and condemnation in equal measure.
This effort has been hailed by some who argue that this is Africa trying to deal with its issues, but it has also been heavily criticized by others who argue that owing its very nature of condoning impunity, this is an effort to subvert the work and the intentions and the mandate of the International Criminal Court.
It is, however, the obligation of the African Union to engage and intervene in areas where certain crimes have been committed, and thus the development of instruments to confirm the rights of people that have been affected by crimes or abuse, a court being one of them.
The principle of the right to protect, in fact, has its origin in the debates and works of the African Union. And so the argument that the African Union takes is that the starting point is that the normative framework, the base normative framework of the African Union confers on it the obligation to do something positive in terms of the search of justice, in terms of ensuring and guaranteeing the larger freedom of the African continent.
With such efforts to see justice for victims of crimes of international nature in Africa, one may therefore ask why the AU was quick to endorse the move by the Kenyan government to have the Kenyan cases at the ICC deferred.
Kenya sought a 12-month deferral in view of the fact that it had, as a country, undergone a transformation that provided for a mechanism to deal with that type of crimes. And that therefore it was part of instituting, once again, the provision of the Rome Statute within the principle of subsidiarity. The ICC is provided for as a court of last resort. And so the argument was, if part of your role is to actually assist countries to build their capabilities to deal with these challenges and risks, isn't it logical, therefore, to provide Kenya the opportunity to begin to build this judicial capacity in a manner that it can deal with these types of risks into the future? This was the argument, and it took the day in terms of the AU summit, and hence the seeking of the deferral as provided for in the Rome Statute itself.
According to Ambassador Monica Juma, over time there has been a thrust in Africa in favor of localized mechanisms which in the view of the African Union are likely to be more cost-effective and more relevant in the view of the realities on the ground. Nancy Njoki, GBS News.